All right, and today we are joined by Heidi Epstein and Emily Peeler from the ABA Center for Children and the Law, and Judge Kathleen Quigley of Pima County Superior Court in Arizona, and our current NCJFCJ president. I cannot do their experience and expertise justice in the time we have today, but I was hoping they can give us a short introduction in just a moment. Before I turn it over to our amazing faculty, I do have to go over our disclaimer. This is in development. This development of the presentation was supported in the agreement by, there's that grant code. Points of view or opinions expressed in this presentation are those of the presenters, do not necessarily represent the official position or policies of OJJDP or the U.S. Department of Justice. Thank you again for joining us today, and I'll turn it over to Heidi.
Thank you. Appreciate that. And I appreciate all of you joining us today. Emily and I, as Fabiola said, are from the ABA Center on Children and the Law. I'm hoping many of you are familiar with it. For those who are not, we are part of the nonprofit division of the American Bar Association. Many people don't realize that in addition to being a member organization, we also have a nonprofit division. So the ABA Center on Children and the Law has a mission of promoting access to justice for children and families. And we do a lot of work sort of at the national, local, state level to improve legal representation and basically system reform when it comes to children and families. We have projects on kinship care, which Emily and I are both from that kinship project, as well as projects on the intersection of immigration and child welfare, education, health, court reform, and just a whole host of other things. If you are looking for any additional information or resources, please visit our website, which is on that bottom of the screen. And that's the end of the ABA commercial. I wanted to take a minute to tell you a little bit about myself. I am an associate director at the ABA Center on Children and Law and head up our kinship work. I do work on a permanency barriers project and tell people that in a past life, I was a children's attorney in New York and Maryland, as well as a residential social worker. So I'm gonna let my colleague Emily introduce herself, and then we'll hear from Judge Quigley.
Hi, everybody. Like Heidi said, my name is Emily Peeler. I work with her at the ABA Center on Children and the Law. I'm a senior attorney there, and like Heidi, I have my JD and my MSW, so try to approach our work from that social work side of things as well. In addition to the kinship work at the ABA Center on Children and the Law, I also do work as part of our foster care and education program, working on K through 12 access and success for students in foster care. I'm going to pass it over to Judge Quigley to tell us a little bit about herself.
Hi, good afternoon, everyone. And it's nice to see some familiar faces and names that are attending today. Welcome all. Just so you know, my name is Kathleen Quigley, and as Fabi said, I'm a judge in Tucson in Pima County, and I've been on the juvenile court bench since about 2009. And so I deal with this kinship placement and where children should be almost every single day in every single case. So I'm really excited to be here and have this discussion because it's incredibly important.
Thank you, Judge Quigley. And please ask questions and interact. We'd love for this to be as interactive as possible. So raise hand, put it in the chat, whatever you'd like to do. But I'm going to turn it over to Emily to get us started.
All right, thanks, Heidi. Like Heidi said, please put anything in the chat or small group too. You might even be able to raise your hand and we'll see that too. And you'll get copies of all of this afterwards. So I wanted to start with the value of kinship care. Why are we talking about kinship care? How do we see it playing out in data and things like that? So starting with some numbers nationally, we know that there are about 2.5 million children in the U.S. being raised by grandparents or other relatives or close family friends, kin. And that for every one child being raised by kin inside of the foster care system, there are about 18 children being raised by kin outside of the foster care system. You can see that in other numbers over here on the right, with the big circle being that 2.5 million and that smaller circle being the just over 130,000 children inside of foster care living with kin. Also, I wanted to tell you about some data that you can find on our website, grandfamilies.org. We put this together this summer and I found it really useful. It reflects 2024 AFCARS data that you can find at the AFCARS dashboard. But this map has, if you went to the website, you could hover over it and you would see the percent of children in foster care that are living with kin And then you can see that broken down by licensed and unlicensed kin. So it's a great map to try to get you familiar with what's going on in your state there. You can see here the colors. The green is the less living with kin, and the blue is more living with kin here. We have seen an increase in the percentage of children in foster care being raised by their relatives. In 2007, it was only 25%, but in 2024, it was up to 39%. So about half of all children placed with kin, about 56,000 children, were living in unlicensed or unapproved homes in 2024 too. So about half are licensed, about half are unlicensed. We'll talk a little bit about some efforts on the federal level to improve that number and get more licensed kin homes, but this is just kind of the scope specific to those kids we're talking about in foster care that are living with kin. Why does this matter? Why is this important? We know that research shows children thrive in kinship homes. And this is outside of the foster care system and inside of the foster care system. You can find this research in a great report by Generations United called Children Thrive in Grand Families. But we see increased behavioral health. We see increased feelings of safety, feelings of cultural identity and belonging, better mental health. The odds of them increasing permanency quicker are there, being placed with their siblings and experiencing increased placement stability. So we see a lot of great benefits for making sure kids are placed with kin caregivers whenever possible if they can't return home to their parents. When we think specific to children within the foster care system, I mentioned that improved placement stability. We've seen that being placed in a kinship family has found to decrease the risk of a placement disruption. And we also see those higher levels of permanency, knowing that children initially placed in kinship families as compared to family foster care were more likely to reunify or exit to guardianship. The data is there to support that from AFCARS 2024, telling us that 38% of the children are living with relatives when they exit care, and 11% of that were children that exit to guardianship. So we see those levels of permanency higher for kids with kin. And then we also see decreased behavior problems with kids that are placed with kin, fewer behavioral problems 3 years after placement than children who are placed into foster care. So we have all this data to back it up. And that is really why we know that we should make this effort to place with kin, to work with kin as family resources, all of those really great things that we're going to talk about today. We also know that kin is really important, especially for our older youth. We've got this graphic here about all the outcomes of students who are kids that have exited the foster care system. But really these older youth, we see them needing permanent connections to significant adults, right? Oftentimes that might even be their parents, an aunt, an uncle, or fictive kin, a coach, a teacher, something like that. So helping them create those permanent connections, even if they're not a placement resource, knowing their family history, so connecting them to blood relatives that can tell them about that family history, helping them create a sense of identity. We mentioned that earlier as well. And then creating relational permanence in addition to legal permanence. So especially if you are trying to put an effort in older youth, I know there's some states out there looking really critically at older youth. Kinship is a great strategy for improving those outcomes. However, there are some legal obstacles for our kin. So, of course, unlike parents, kin lack that automatic legal relationship to the children that are living with them. So they might struggle with things like accessing medical services, accessing education services, those sorts of things. Sometimes you need that legal relationship to do that advocacy, or even simple things like enrolling them in schools. To get that legal relationship, it can be really costly and it could take a long time. We'll talk a little bit about how we can help that. But it's also important that kin understand all of their options. We'll talk a lot about options today and the role legal professionals have in making sure kin understand their options and picking the best options. It really is the responsibility, not just of legal professionals, but all those professionals interacting with them to help them understand those options, because it's confusing. Also, keeping in mind that families are their own best expert, but they need that accurate information to make the decision that works for them. So we talk about options, but also how does that fit into their current family and child needs. So those are some of the obstacles we know that they're facing, and that's why we've created this kinship legal toolkit. Before I dive into that toolkit, I wanted to flag for you all that there is an NCJFCJ Judges Action Alert coming to you soon, specific to kinship. It will reflect a lot of what we're talking about here and then some. So I encourage you to check that out when you get that alert in your inbox, because I think Heidi did a really great job of writing that. So what is the role of legal partners in supporting a kin-first culture? Judges and attorneys, of course, are critical to making sure that anybody with an important relationship to the child, whether that's a blood relative or fictive kin, are given an opportunity to stay involved in the child's life, including helping foster what we're calling a kin-first culture. I'm hopeful you've maybe heard about a kin-first culture before. If not, we're going to tell you about it. But that means really helping prioritize the placement of children with kin whenever possible, ensuring that kinship connections are maintained while a child is in care, whether that's a placement resource or other, and promoting permanency with kin if they can't safely return to their parents. So we'll talk about some permanency options later and how to engage those kin. All of that is within our kinship legal toolkit. So our legal toolkit has 5 big topics. Each of them have an overview, tips, a quick guide, and links to resources. I'm going to actually escape my presentation right now and show you how you can access this kinship legal toolkit. So right now I've taken you to grandfamilies.org. This is a website that is all kinship. You can search laws. I'm sure all the lawyers love that. But if you wanted to find our kinship legal toolkit, you'd go over here to resources and scroll right down here to kinship legal toolkit. And when you open that, you can see our 5 big categories here. We've got background, kinship laws and research. We've got building blocks for a kin-friendly courtroom, identification, notice, and engagement of kin, placement with kin, and permanency with kin. And then we've got this other section here where we have a judicial bench card and some videos from lived experts. If you click on any of those 5 big topics, you'll get to our overview and our concrete tips for how to. Right now, this is building blocks for a kin-friendly courtroom, and you can see on each of those topics right here a button to download a quick guide. I think the quick guides are my favorite. None of them are more than 2 pages long, so they're really easy to print out as resources to share with any of the legal professionals you're working with, or even non-legal professionals that are interacting with people in the courtroom. We have our judicial bench card here. I also really love our judicial bench card because it goes by court hearing type and talking about specifically what judges could be asking, what questions should be happening around kinship care for each of those types of hearings. And this page is also where you'll find our video series with voices from the field. We've got a youth perspective, a caregiver perspective, and thanks to Judge Quigley, we've got a judicial perspective as well. So really encourage you to check this out after the presentation and even watch some of those videos. Well, let me pull myself back in.
One thing I want to mention also, on each one of those pages, you will also find some national resources at the bottom.
Yes.
So in addition to our tips for each subject, whether it's placement or kin-friendly courtroom, et cetera, you're also going to find some national resources to give you a little bit more information on that topic.
Thank you, Heidi.
Sure.
And again, you can find all of that at grandfamilies.org, and that is a little teaser for what the rest of this presentation looks like. And I'm going to actually pass it over to Heidi to get us started on background, laws, and research.
Thank you, Emily. And one thing I really want to mention about the toolkit, and I've put that in the chat, the link, is the work that Emily and I do on kinship and have been doing for many, many years. We often get a lot of buy-in from the social work community and the caseworker and the agency about what their role, they understand. Their job is to find kin, to place with kin, et cetera. The reason that this toolkit came about was for years and years and years, we've been trying to sort of get people to understand that there is a very important role for the legal community as well in supporting what we call a kin-first culture. So the beautiful thing about this toolkit is it doesn't just cover sort of kinship generally, which we, Emily just did a nice sort of overview of the concept of kinship care, but we try to go deep on what judges need to do under this topic. What do the children's attorneys need to do? What do the agency attorneys need to do? And what do the parent attorneys need to do? So really kind of allowing legal professionals a little guidance, some tips, some resources to help improve your legal practice around the idea of kinship. And so the first section we're going to talk about today is the background laws and research section. I also want to say Dave Thomas Foundation was kind enough to support our work in creating this toolkit. So decades of federal law, I am sure that there isn't a law up here that most of you are not familiar with, but what we like to really show in this graphic and what we go into when we talk about the federal law in the toolkit page on this topic is what are the kinship specific provisions. So I'm sure most people are familiar with ASPA and fostering connections, but instead of doing sort of a deep dive on each one of these laws, what we do is pull out, these were the kinship provisions. This is the thing that was significant for kinship with regard to this federal legislation. I always joke that for a while, it seemed like every 10 years we get another big piece of federal legislation that everybody would kind of scramble and figure out how to implement. But really focusing again on what are the pieces of kinship that grew out of federal legislation, starting with placement preference and all the way up to the most recent Supporting America's Children and Families Act. So really thinking about things like notice, which we're going to talk about, placement preference, subsidized guardianship, and we're going to cover all of that today. But all of those concepts are grounded in federal law. So that's what this section is. Additionally, we have some information about constitutional arguments that can be made to support kinship first culture that were upheld by the Supreme Court. Things like the children's right to family integrity without state interruption, which includes the right to remain living with parents, with siblings, and it's mentioned in several cases, kin caregivers that they have a relationship or no. So making sure that we are supporting those children's right to family integrity. Also acknowledging and understanding parents' constitutional interest in the care, custody, and control of their children. We talk a little bit about there was a Supreme Court case called Troxel v. Granville, for those of you who aren't familiar with it, that really looked at sort of the conflict between a parent's right to parent and a grandparent's right for visitation. So really some interesting sections of this toolkit looking at what kind of arguments and what case law you can maybe bring into your individual cases. Or if you're a judge, you should be considering when making your rulings. So then the next section is the building blocks for a kin-friendly courtroom. All of the work that we put into this toolkit was a lot of fun, to be honest, and pulling it all together and really thinking of it from a legal lens. But I had the most fun with this section, to be quite honest, because I thought, what does that look like? What does a true kin-friendly courtroom look like? And we're going to hear from Judge quickly in a minute about what that really looks like. But thinking about things like giving meaningful participation engagement of the youth who are in court, parent, and kin during court hearings, supporting the family and understanding that when you're placing a child with a kin caregiver, there are things to take into consideration, like the changing dynamics among the family that you don't have when you're placing a child in a non-kin foster home. What can we do to minimize the trauma of court hearings and ensure we have family-centered practices so that they feel comfortable in court? Informing kin of their choices and making sure they understand their options and rights, which you're going to hear a lot about. It's kind of an ongoing theme through the toolkit, but also making sure that kin walk away understanding what has happened at the hearing. As Emily mentioned, most kin do not have an attorney. They do not have an attorney to walk them through, to see them as their client and to try to help explain the system to them. It's very complex. Many of them step up at the last minute to try to assist their family, not really understanding the child welfare system. I often talk about kinship care and child welfare as the round peg in the square hole. Kinship care is this naturally evolving concept. Most people know somebody who is at one point or another stepped in to care for a child that they're related to or have a family-like relationship with. But child welfare was not designed or built around that idea. So really trying to marry those two concepts. And then finally, that the court holds all professionals accountable for effective implementation of all kinship laws and policies. So that's really kind of what was part of the building blocks for a kin-friendly courtroom. Next slide. When we think about how can judges effectively engage kin, and then again, we're going to get to hear from Judge Quigley in a minute, but under federal law, kin caregivers, in addition to foster parents, have the right to notice of all hearings and not only notice of the hearings, but right to be heard. It's been very interesting as we do these trainings to hear from folks about how many of you routinely ask kin caregivers questions from the bench? How many of you attorneys routinely make sure that kin have a voice in court during your hearings? And I know we're all really pressed for time for in hearings to make sure that everyone gets heard, but I think it's really important for many, many reasons. Namely, kin caregivers are the most useful, I think, source of information about how the child's doing on a day-to-day basis. They're the ones that are spending the most time with the children. So in order to make informed decisions and guide decisions about the child's future and their life, it's really important to hear from the person who's with them every day. Again, making sure that it's very family-centered and trauma-informed so that they're comfortable sharing that. So we often say judges should ask kin about things like the child's progress and needs, finding out what the kin caregiver's commitment to the child is, knowing that reunification is always the ultimate goal, but if they cannot reunify, are they there for a long-term commitment? Whether they're receiving services and supports, are the kin caregivers getting what they need to care for the child? Thinking through the impact of placing that child in the kin caregiver's house on the relationship between the kin caregiver and the parent, the child and the parent, and what are we looking at with the changing family dynamics? And then finally, any opportunities the kin caregiver might have had to speak with a lawyer or an advocate. So now I'd love to hear Judge Quigley's thoughts about this kin-friendly courtroom concept.
Well, I really think that the kin-friendly courtroom starts at the very first hearing. And I will tell you, my experience is that's where most of the kin show up, or the family members show up, is the very first hearing. And so I think it's really important to make them feel welcome, ask their names, how they're related to the child or to the parent. Are they an aunt? Are they an uncle? Are they a teacher? Are they somebody that's close in that child's life? Find out. And then write their names down. I think just from a practical standpoint, write their names down on their relationship, put them in your notes. So for the next hearing, you can refer to them by name. I think it's just as important when we call parents by their names, Mr. or Miss, that we call kinship by their name, not grandma or maternal great-grandmother. I mean, that could be part of it because sometimes you need to delineate that for the record, but they have a name. And as simple as I have in my courtroom snacks, and I think a lot of judges do. I have snacks and I have water, and I offer those to everybody that comes in. And actually, on one of my judicial performance reviews, somebody wrote a comment and said it was very intimidating going into the courtroom till the judge offered us snacks. And then I think it lowered the level of stress for them. And so if you're able to do that, that's something you could consider. I think it's also great when you have kids in the courtroom or teenagers because they're always hungry, or you have a parent who comes in the morning and they're hungry. I had a parent come in one time and she did her best to get to court, but her car had been repossessed the night before, and then she had to borrow a car and got there. I'm pretty sure she didn't get any breakfast. So I just think making your courtroom feel welcome, making them feel welcome, letting them know that you would like them to come back to the next hearings, that you want to, if they're considering taking the child, make sure they know, just as Heidi pointed out, what the requirements would be. Cases where I've seen somebody say, wait, I'm willing to take the child, but I thought I was just taking him for 4 weeks. I didn't realize it was going to be 6 months or a year. So it's really important that as a judge or as an attorney or as assistant attorney general, that you make sure that they really understand. I think a lot of times it's easy to we do this so much that we forget where the gaps are and what the holes are and what they don't understand. So making sure we can fill those in and asking for them. And sometimes somebody can't be placement, but they might be able to take the child to soccer, take them to their football game, take them to the religious services that the family practices in, take them out to dinner once a week, unsupervised, whatever it might be. They may not be able to be placement in their schedule. So that's why I think it's really important to ask. And I think sometimes the department they're good at it, but sometimes I think you miss things. And so I think by encouraging the department to keep a relationship with family outside of the courtroom, between hearings, encouraging the attorneys to do so. I find oftentimes that the least informed person in the courtroom is the judge. And so I think that's why it's incumbent upon us as judges to be very curious and to ask questions and to encourage the attorneys to bring the information to us. So I also think when the next hearing comes, it's good to reach out and to try to set enough time in your hearings. I know they're really can be pressured sometimes, but when you have the time, ask them how it's going. Have you reconsidered? Are you able to take this child? Are you able to be any part of this child's life? Do you have any recommendations? Is there anything that you see that you're concerned about? And I think that really informs. I had actually a grandmother on today who said, I'm at the hospital with my granddaughter and she's placement, and she said she had a seizure. And she asked, I was really admired her. She asked and said, I really would like my daughter to be in the home more to help me because I work from home and I watch these children, and this child in particular has special needs. And so she asked if she could have the mother there more often because she was supervising part of the visits. But thank goodness she advocated for herself. But had she not, it would have been, I always, it's good to ask, how are things going? What do you need? What does the child need?
Thanks, Judge Quigley. That's a good segue into our next section about kinship identification, notice, and again, emphasizing the importance of engagement of kin caregivers. So we've got 4 key steps to engagement of kin. And this kind of looks not just at judges, but also all those legal professionals, parent attorneys, children attorneys, agency attorneys, but really reviewing efforts that the agency has made to identify and locate those kin. We think about that a lot at the beginning of a case because that's where some of those notice requirements are. Within the first 30 days, you've got to provide that notice. But really, that should be happening throughout the life of the case, even if they seem like they're in a stable placement or anything like that, because maybe that placement's going to disrupt, or also maybe they need some of those family connections we talked about early. So reviewing efforts to identify and locate kin at the beginning and throughout the life of the case, making sure you're including maternal, paternal, and tribal relations and any individuals with significant relationships to the child or family. So we're looking at blood relatives on both sides. We're looking at kinship, potential fictive kin, caregivers, just making sure that when we're talking about that notice and that identification, we're looking all over. And making sure, and this is especially true for those children and parent attorneys, that they're asking the parent directly, asking the child directly to identify the people that are important to them. Who do they go to for support? Where do they spend their holidays? And who could be a potential placement resource? Because remember, it's not just about placement, it's also about those connections and that support, just like Judge Quigley was saying, to support with that caregiving sometimes. Also, you want to confirm their diligent efforts to notify kin, right? So ask very specifically, was notice provided within 30 days in an easily understood and written format, and to whom? Hopefully the agency can tell you, yes, we did that. Yes, I can show you that letter if we really want to see that letter, and who they were able to provide notice to. But also make sure that that notice that they're giving is including all of the various options to participate, what the foster care requirements might be, and any available services and supports for those kin caregivers. So they really start to begin to understand all of those different options and all the different ways that they could be involved. There is within the federal law an exception for the notice requirement for any family or domestic violence, and that absolutely should be used when appropriate. But a role, especially of the judge, is to question that use and make sure it is being used appropriately and not being used as an excuse for not notifying some kin caregivers. So that was our second step. Our third step is really talking about meaningfully engaging those kin, making sure all of the attorneys and the judges are communicating honestly with the kin while focusing on strengths of the family and actively listening to each family member. So Judge Quigley was saying there was a kin caregiver who said, oh, I just thought this is going to be for a couple of weeks, right? So making sure they're understanding the consequences of their decision, whether they're positive or negative, and all the different options, including those options as placement, how that placement might impact permanency options, what type of support comes with all of the different options, and things like the visitation resource. Can they supervise visitation? Can they drop them off at soccer, like Judge Quigley was saying? All of those different options for assisting the family and the child. And making sure you're asking and providing to the judge at every hearing what steps have been taken to engage those kin caregivers. If we've identified kin that could be placement resources, ask why they're not with those kin. Are there barriers that the court could help you overcome to get that child placed in a kinship home? If the child is always talking about grandma, what are we doing to help engage grandma in this, even if she can't be a placement option? So just asking, again, throughout the life of the case, what steps are being taken to engage kin that have been identified. And then once you have those connections going, the fourth step is to support those connections. So ask how children are maintaining those connections with kin, consider issuing enforceable court orders or requesting court orders for regular visitation, regular communication with kin, but also with siblings. Siblings are definitely a part of this. And then for those kids that might be in congregate care settings, in group homes, ask about how kin are being involved in their treatment, in their discharge planning, as well as for older youth, thinking about the role of kin in their transition plans. Like I mentioned before, kin can be really important for those youth that are aging out of care. So making sure that if they're kin that they're relying on for support, that they're a part of those transition plans. I just said a lot, and I think I echoed a lot of what you already said, Judge Quigley, but do you have anything else to add about notice, identification, or engagement?
You know, one thing I find is interesting is that oftentimes at the first hearing, parents are very protective of their family, of everything, or they're embarrassed and they don't want to let names out. So what I have found to be really helpful is that, especially if they found maybe a potential kinship placement, is I'll ask the parents and say, or if the child's in foster care, and say, do you have anybody else? Do you have any family or friend that could be a positive support to you or your child? And then I'll explain to them why and tell them, because your child's in care right now, if foster placement needs to leave town unexpectedly, something goes on in their life, or kinship placement if the child's in kinship, and they are not able to take the child with them. He said, you don't want your child going to a stranger. You want them going to somebody that they know and that cares about them, and who they have a relationship with. I said, so we need those names to be able to provide support, somebody who could supervise your parenting time, somebody who could support the placement, or be there for the child in other ways. And so then I find there's kind of a sigh, and then if especially with I see two parents, they'll start looking at each other and saying, wait a minute, what about so-and-so? So I think just by, you know, this is again goes to the building a kin-friendly courtroom and making it, you know, people feel like they can say something. It's intimidating to come into a courtroom and not know if you can say something or not say something. And so I think if the judge is inquiring or asking, or the attorney is asking of their client and explaining it, I think that really helps. And we all know that, especially with teenagers and little ones, they need to be somewhere where they're loved, someone who can hug them and love them and tell them, happy birthday, have a great day, I love you, I'm sorry you're so sad. And while you can build a relationship with foster care, you can't build that for a while and build that trust. So the faster we can get children into these types of situations, the better off for the child.
Thanks, Judge Quigley. I'm going to pass it over to Heidi now to talk about placement with kin.
Thanks, Emily. One thing I do want to say with regard to the role of support for kin, I think something that people don't always think about is that the role kin can play in supporting the parents. So I know we focus a lot, as we should, on the role that kin can play in supporting a child who's going through this, but oftentimes looking at relatives as a support network for the parent as well. Can they, if the parent is having transportation problems, can they drive them? Can they supervise visits, even if they're not the kin caregiver? So really thinking of kin in a broad way as part of that full support network, I think is important. And the first thing we think about kin when a child comes into care is as a placement. So placement with kin, really thinking about what that role is as a legal professional in ensuring kinship placements. So we know that there are federal placement requirements. We know that the child needs to be in the least restrictive family-like setting. Often kin can provide that least restrictive setting. We know that the federal law requires siblings be placed together unless contrary to their safety or well-being. Data shows that kin caregivers are more likely to take those large sibling groups into their home and prevent breaking up siblings from having to live in different homes. Thinking about the placement preferences under ICWA as well, in absence of good cause to the contrary, if you've got a Native child. I often get the question that there are so many different federal placement requirements, things like the least restrictive, close to the parent, maintaining school of origin. Like there are a lot of different criteria when you're choosing a federal placement or a placement, frankly, that need to meet the federal requirements. And I get this question all the time. What's the most important one? Is it kin over siblings? Is it kin over school? Is it kin over close to parents? There's no great answer. There is no answer. And the federal government doesn't tell you one of those placement preferences is more important than the next. I think as a legal community, just understanding all the requirements and doing the best we can to find the best placement for the child. With regard to considering party preferences, as Emily mentioned, and the judge also mentioned, talking to the parties about what their preferences are, helping children express their preferences and weigh a preference of the child's heavily when you're looking at a placement decision. I think something to understand, however, is at times you may have a parent who is opposed to a kinship placement. It happens. And so the other question I get is, well, if the parent is the reunification resource and they don't want the child to go to, say, their sister, do I still place with the sister? And I always follow it up with a question, my favorite thing to do when someone asks me a question. And I say, did you ask why? Did you take a minute to say, why don't you want the child with their aunt? And to really kind of dig into the why. And not just say, well, mom doesn't want the child there, therefore we're not going to do it, or it doesn't matter what mom wants, we're still going to do it. Either way, you have to consider that we are involving ourselves in the family's life and that there is a whole history before we get involved. And to understand that history and think about what is our role to support it. So if the decision is to still place the child with the aunt despite the parent's objection, what can be done to rectify whatever the bad feelings or whatever the conflict is between the kin caregiver and the parent, and to just be aware of it. So yes, consider party preferences, but among other things, those have to be weighed. All right, next slide. So weighing all those factors. If the child is not in a kinship placement, at every hearing, ask what is being done, why aren't they a kinship placement? You really want to avoid having to move a child from home to home to home, having a child bonded with a foster family only to find kin later and move them to the kin's home. I'm not saying you wouldn't move them, but what you really don't want to do is if you could have found that kin and engaged them at the beginning and prevented that movement, because every time they move from home to home, that's a problem. So really thinking about how can we get them with kin right away? If siblings aren't together, asking why they aren't, making sure they have frequent contact and visitation, thinking about the type of kin placement and does it impact the desired permanency outcome. So finally, what can we do to support that it's a successful kinship placement? Thinking about what are the supports that are available for the kin caregiver. Number one, if kin are not licensed as foster parents, and about half the states don't require children in the custody of the child welfare agency to be with a licensed kinship caregiver. They can live with an unlicensed kinship caregiver. But if they're not licensed, ask why they're not licensed. Make sure it's their choice. Make sure that if there's a barrier to them being licensed, that the agency is working to overcome that barrier. There are waivers, there are exceptions, there are kin-specific licensing standards we're going to hear about in a minute. But ask questions. And again, find out that it's what the kin caregiver wants. Unfortunately, sometimes the conversation between the child welfare caseworker and the foster and the relative is, do you want to be a foster parent for that child? And you have sort of a visceral reaction. I don't want to be a foster parent. I'm grandma. I don't understand. Or, I don't want to feel like I'm taking money to care for my own grandchild. That's not it. The financial support is to help care for the child. If anybody's raised children, they know they're very expensive. And these kin caregivers come and do this because it's the right thing for them to do. They want to support their family, but it is not easy to do that without any financial assistance. So really trying to understand why. And sometimes when they have that conversation, the caseworker will say things like, oh, you have to get fingerprinted, you have to go to training, you have to do all these things, but you don't want to do that. We're going to just put the child in your home. So making sure that they're really educated about what it means to be licensed and what comes with the license and what are the benefits of licensing. We'll talk about that in a minute. But understanding that the type of placement that they have with the child does impact their benefits, their rights, and their responsibilities, and making sure they understand that and that they're getting all the supports they need. All right, next slide. So I don't like to just talk about money. I think it's really important. It's an important piece, as I just said, raising a child is not cheap. And that's only one type of support that's available. There's all kinds of other supports and services. But I use this chart to just really make sure people understand the difference between being licensed and not being licensed. So these are national average numbers. Every state's different. But typically, if you are caring for a child outside of foster care, or you're caring for a child inside of foster care and you're not licensed, that's that first green column. You're most likely eligible for child-only TANF, maybe or maybe not Medicaid. If you're licensed, you are eligible for the foster care maintenance payments at the same rate that a non-kin foster parent would be eligible to receive. Again, you're not paying them to care for the child. You're providing support so that they can meet the child's needs, food, clothing, all of that. And then finally, kinship guardianship assistance and adoption assistance if they choose to become permanent options for the child. Looking at this chart, if you're taking one child into your home, there's not a huge difference. I mean, it's still big, but $469 to $958 a month. It's still a big difference. The difference really happens when you start taking 2 or 3 or 4 children in your home, because that first green column does not go up per child. It only goes up in a small amount. So you go from $469 to $583. Whereas if you're licensed or you take guardianship or adoption subsidy, you're going to double because you have 2 children. You're going to triple because you have 3 children. But TANF doesn't operate that way. So these are the kinds of charts that I tell people, get that filled out in your own state. Know those numbers. Educate yourself so that you can have a meaningful conversation with kin when they say, no, I don't want to be fingerprinted, or no, I don't want the social worker in my house, etc. They need to understand what it is they're sort of giving up, unless there's a barrier like criminal background that's insurmountable. But really making sure that kin caregivers understand the difference and that we as legal professionals understand the difference. And it's unfortunate. We are working really hard at the national level to erase what we call the kinship inequity. And that inequity is that green column should look exactly the same as those blue columns, but they don't. This is just the reality of where we are right now in the world. But it is certainly something we're working on. All right, next slide. So really exciting. In 2023, the federal government said, you know what? We acknowledge that placing a child in kinship home looks different than when you're placing them in a foster home. Someone who comes forward and says, I want to be a foster parent versus someone who is sort of thrust into the situation because of the child that they're related to or know or have a relationship with. So for the first time ever, the federal government said, I think we can have different licensing rules for kin. And it's not a lessening of safety. I want to be very, very clear. What this is the flexibility to understand things like if the child wants to live with grandma and the only thing grandma has is a pullout, that's okay. It is not unsafe. But many states would say, no, they have to have a separate bedroom. They have to have a bed. This is our licensing criteria. And that could be very well true for a non-related foster home because we have certain expectations of those homes. This is something they're pursuing versus a relative. So looking at kin-specific licensing and the flexibility allowed by having different standards. So very excited to show you the map. The map shows you that 17 states and 6 tribes so far had kin-specific licensing standards that have been approved by the federal government and that look different than licensing of a non-kin home. And if you go to our website and you click on any one of those green states, you can see what the rules, the regulations, the laws, the policies, and some of the forms for all of those states that have been approved. And we're hoping one day that the whole map is green. So what are some of the benefits of these kin-specific resource home standards? As I said, it allows flexibility without compromising safety and well-being. You still need to assess the home. You still need to make sure that it's a good fit, that kin caregiver can meet the child's needs. So it's not a lessening of their ability to meet needs. It's not a lessening of safety. You're still going to do that good assessment. But some of the silly things like they have to have windows are of this size. I work with a state where you couldn't own a Rottweiler and be a foster parent. Don't ask. You know, there's just like a lot of licensing standards that just don't make a lot of sense. But frankly, someone sued someone, we lawyers, and it suddenly became a licensing standard. So kinship licensing standards allow for more flexibility, which we hope results in more children in place with kin, streamlined process, reducing administrative burden, eliminating standards that negatively impact kinship families, especially those who are in rural or lower socioeconomic, encourages kin as the first and hopefully only placement for the child, and a step towards supporting kinship families with equal foster care maintenance payment. Why would you, and many states did this, provide a stipend for the foster parent, but for the kin, they said, oh, you're kin, you get less money. The child's needs are the same. It makes no sense. So the federal government said, not only can you do kin-specific licensing, you must provide the same foster care maintenance payment. And then finally, it eases the path to kinship guardianship assistance, because in order to qualify for kinship guardianship assistance, you must be licensed. So licensing is really sort of a gateway into the support and services for a child in foster care. All right. Judge Quigley, thoughts about placement?
Yeah, so I just think it's important just to be clear, and I think it's good to have everybody on the same page. And if you're a judge, have those in your courtroom understand your expectations. And I love what Heidi shared about the discrepancy between what the payments are based on children, based on licensed or unlicensed. And I think it's not a bad idea for your court to consider putting something together for families to give out in the courtroom. We've done something like that on guardianship to help them really understand the difference between guardianship and adoption. And I think it's really important because these are important decisions that they have to make when they're caring for these children and taking them into their home. So I love that Heidi shared that. And I think that's something, and that helps prevent miscommunication. I think it's important to ask questions. I love Heidi's question is like, why don't you want this child to go there? Why can't you take the child? Is this something we can address? Is there a barrier we can get over? And just make sure that they understand, take some time. It's worth it. It pays off in the long run as the case goes on, because as Heidi said, we don't want to be moving these children from place to place. And we'd rather get them in a kinship placement if possible. And I'm not saying that foster care, foster care sometimes is maybe the best place for a child to be. So do not think that it's not an option, but kinship oftentimes is always the best. I don't find as much disruption with kinship placement and family as I do sometimes with foster care, especially with older children. Heidi mentioned early on about children that go into, or maybe it was Emily had mentioned, but they talked about children going into treatment. And there was a case, a young woman I met, she was 22 years old. I just met her in September, I think it was. And she was one of 4 children. The children were not placed with kinship. They were separated. The kids had finally had it. At one point, they were visiting together, the children, and they kind of locked their arms and said, "We're not going anywhere. We want to be with family." And there was a grandmother that nobody had really looked at, and she was a teacher, and this 22-year-old had been in a treatment facility, and she was adopted by her grandmother along with her siblings. They'd been out of the home for 5 years. That child is now a college graduate, and she is doing great things, and she's looking at going to law school. So it made a difference in her life and completely switched it around. And it was the children that forced the issue. So I think it's really important to look at that, and why. I don't know what happened with the grandmother before, but she was perfectly appropriate. So make sure you inquire, make sure you ask. If you're the judge, make sure you're the judge in the room that knows everything that's going on and asking questions and you're curious. And if you're the attorneys in the room, make sure that you're getting as much information from your client. If you represent children, make sure you're asking, make sure you're looking at the family, because if the department is not able to look, and oftentimes I'll find somebody will ask for a child to go with a relative and then not file a motion to have that child placed there. All I can assume is that they found a reason that child shouldn't go there, but I don't know that. So always. And so I think it's really important to ask those questions. So I think ask away, be curious.
That's great. Thank you, Judge Quigley. Honestly, I love the idea of the judge and the attorneys asking the kin caregivers what they need to support the placement too, because a lot of kin caregivers tell us they are afraid to ask for anything. If they say, we need some help with heat this month, or we need help with, finding the right size shoes for the child, whatever. When they ask for assistance, oftentimes, not always, but oftentimes the agency's response is they can't care for the child. They need help, therefore they must not be able to care for the child and meet their needs. And so they're afraid to ask. They are afraid to have that child removed from their home. And that is the fear of being in child welfare. Oftentimes for relative caregivers is that at any moment, they don't have that control to determine whether this child stays with them. And they'll tell you, no matter what, I want the child with me, no matter what type of placement, what type of permanency, they want the child with them. So they're really afraid to ask for things. The other thing is the complexity of this area of law. I joke that when Emily and I go to a new state, it takes us a while to get up to speed to understand the state's kinship laws, policies, practices, etc. It's really complex. So you can only imagine how the relatives feel when they're thrown into this complex system, having no background and not having a law degree. So really it is on all of us as legal professionals to make sure they're really understanding their options. Again, they don't get an attorney. So thank you, Judge Cooley. That was really, really helpful.
And I think, Heidi, you make a good point and as well. And I think the other thing is sometimes there's shame. Sometimes they're embarrassed that they maybe don't have everything that they might need to take the children into care. So make it comfortable. Let them know it's okay that they don't have anything. Nobody expected that they would be taking this child. So I think or the sibling group. So I think it's really important to make them feel comfortable, make them feel like they can ask questions and ask for what they need.
That's great. And something you had said, Judge Quigley, about sometimes foster, homes are the best option. And I totally agree. I've met incredible foster parents. I want to make sure that it's very clear that our perspective is not it's kin at all costs. So if the kin cannot meet the child's needs, if the kin is not appropriate, if the kin comes in so late in the case that it's very disruptive for the child and it's a difficult situation, it's not kin at all costs. But this is why we want to identify kin early, engage them, place with them, and support them. It's really important. But again, not kin at all costs. I want to make sure that we're very clear on our kin first culture is to do the best we can to keep children connected to their family. But obviously their needs have to be met as well. So great. Okay. Last section, permanency with kin. So we all know that we have really tried to hopefully understand that reunification is the best option. That when at all possible, we really want the child to reunify with the parent. Can't always happen. And so again, you get caregivers who think it's for a few weeks, a few months. Next thing you know it, they're raising the child for the rest of their lives. It's just what happens. And very few kin realize when they step up that this might be it forever. So we have sort of two different paths to permanent kinship families. We have those inside the foster care system, which we really have focused on a lot today, and those outside the foster care system. So for those inside the foster care system, the agency, as you know, I'm sure, has legal custody of the child, and that there are often two options, the licensed and unlicensed, which leads to different services and supports that we already talked about, and understanding that if they're licensed, they're the permanent option for the left-hand side of or the right side, I'm sorry, the red side, is they can become the adoptive parent, or in most states, they can have subsidized guardianship. We'll look in a minute which states have subsidized guardianship. When they go for adoption or subsidized guardianship and become that type of permanent family, they get legal assistance that is paid for up to $2,000, and then they get that subsidy, which is ongoing. Those are outside the foster care system, and there are many kin who say, you know what, I understand I'm not going to get the same financial assistance. I'm not going to get an attorney. Thank you very much. I'd really rather not enter the system. I just want my grandchild, aunt, niece, nephew, etc., cousin. So those outside the foster care system, they don't have that automatic legal relationship to the child. They need to come to court to get some form of legal relationship. And in the toolkit, we try to do it from sort of a national level, looking at custody and guardianship laws and subsidize things like temporary custody and all different types of guardianship and custody, but obviously needing to understand it for every different state. Powers of attorney, temporary custody, some states have medical and educational consent laws. So there's lots of really good information in the toolkit around caring for the child and permanency, but understanding that there is no automatic legal relationship, no legal help or ongoing financial support if you decide to go outside the child welfare system, which if you remember Emily's graphic in the beginning, 18 or 19 children to one are being cared for outside the system. So great. So permanency with kin. So we've talked a lot about their options and really helping to weigh in on those options and understanding that including parents, children, and kin in their decision-making is really important. That they really should have a seat at the table in helping, and respecting the family is the best expert of their own family. And that there are certain things that may impact the permanency decisions. For instance, things like tribal adoption, looking at sort of the cultural stigma that may be affiliated with adoption in their culture, really trying to understand sort of the family's perspective with regard to permanency. When looking at permanency, we want to make sure we're looking at things like post-permanency support. What is available for the relative who takes in that cute little 3-year-old, next thing you know, they're a teenager. I always joke, that's the time when you want to give them away. But what is that post-permanency support that's available? What can they then get later to help them and keep the placement from disrupting? What are the services and supports, and making sure they know that before they leave the courtroom? Crafting orders that detail post-permanency contact. I've worked with a kin caregiver who said, I had no idea that my guardianship was going to require me to do weekly visits with the parents. No one told me that. The next thing I knew it, I had this court order telling me this is what I had to do. Making sure that everybody's very, very clear about what post-permanency contact looks like, and everyone's either in agreement or the judge finally makes a decision one way or the other. But making sure the order is really clear about what post-permanency contact looks like. Making sure kin understand with each option their benefits, their rights, their responsibilities, the limitations, and the financial assistance available. Because as we know, there are power of attorney, consent laws, guardianship, custody, they all look different. But ultimately, the kin needs to understand that when they take permanency of the child, that means the agency and the court are no longer involved. And that's a really, really important piece to convey to them. I'm going to take a second to just look at the chat to make sure there isn't anything. I think people are just commenting, but no questions at this point, I don't think. Right. Okay, great. All right, next slide. So we mentioned guardianship assistance program. Happy to say that most states, there are 8 that don't, but most states have subsidized guardianship assistance, which was an option provided under the Fostering Connections Act, which allows for a subsidy similar to adoption assistance, but does not require the parent's rights to be terminated. Could be modified at some point later down the line. Most states allow for that modification. But they do have to be be in a licensed foster home for 6 months of caring for the child prior to being able to be eligible for the guardianship assistance program. There are lots of other eligibility criteria, things like the child over 14 has to be consulted. It has to be determined that reunification and adoption are not appropriate and not the best option for the family. But some of the benefits are, and believe me, when I practiced in Maryland and New York, we didn't have subsidized guardianship. I would have loved that. I had so many relatives who told me things like, I would care for this child for the rest of their life, but I do not want to terminate their parents' rights. And so knowing that guardianship assistance allows for that permanency, allows for that subsidy, and supports that concept that you can give permanency to a child without terminating rights. So that's one of the biggest benefits, as well as the support that continues after the guardianship is executed by the court. And then finally, things like successor guardianship, which I think is a fantastic option, that you name a successor guardian, it's just like what a parent does in a will. If something were to happen to me, this is who I want to care for this child. So being able to name that successor guardian prior to entering into that guardianship agreement, and then God forbid something happens or the guardian can't care for the child, then the successor guardian would be evaluated at that point to make sure that they really, although they were named successor guardian, they are the appropriate placement for the child. All right. So obviously, it really depends on the permanency option, what the sort of nuances are for helping kin understand these options. For subsidized guardianship, they have to be eligible, and they need to know how to receive that subsidy. I think it's important when a kin caregiver takes guardianship to understand that the parent can regain custody and ask for a modification at any time. So making sure that's clear and looking at what is the criteria, is it a change in circumstances? What is sort of the threshold in your state to change a guardianship case? And then again, as I said, making sure you have post-contact orders and that the kin understand those post-contact orders. Exploring if adoption is right for the family, making sure they understand that means you are now the child's legal parent and their rights are terminated. And that they understand that there is a subsidy available if they qualify. And then things like open adoption. If you're in a state that is open adoption, making sure that's in the order that the person who's adopting really understands what that means. For kin who are interested in unsubsidized custody or guardianship, making sure that there are supports, services, and benefits in place to make sure it stays a stable placement, and making sure that that kin caregiver can meet the child's needs without agency involvement. That if they agree to take guardianship or custody and the parent shows up and is having a problem, there's no caseworker to call anymore. So really understanding what that means. And for children aging out of care, making sure kin are involved, they're part of the transition plan, they're that support adult for the child. The child suddenly turns 18 and they think they're grown up and they leave the system, or if they stay till 21 or 22 in some states, it's difficult. They need that support network. I don't know. I still sometimes call my mother with questions. I mean, we don't just magically grow up. So making sure they have that support network for them and they know who to call before they exit care is really, really important. And it's another reason to make sure that they've maintained relationships throughout. If anybody's worked on an older youth case where they did not maintain connections with their family and suddenly they were aging out and they were scrambling to find that support network, that is not what we want. We want them to keep that family for the whole time that they're in care. All right, that was a lot of information. There's even more in the toolkit. So we hope you spend some time going to the toolkit and really exploring all the resources and information that's there. We are available to work with states to bring this toolkit to your state, to your legal professionals, to your judges, to your attorneys. We will work with states as well to bring it to your state and make it state specific. So we are looking for a few states to do that, but we are open to having a conversation. I know we've got some time, so I'm gonna just throw up our contact information on that last slide there, and I'm gonna take a minute to look at the chat. Thanks. So please unmute yourself and ask questions if you like, or comments. And I like the comment about sometimes they're open with the judge. When I was practicing, I used to joke, like we would ask a parent, like maybe ask a mother who's the father, and they'd say, I don't know, but then the judge asks and they give a name. I call it, black robe syndrome. And it's really incredible what a judge could accomplish from the bench. So yeah, that's a great question. Great observation.
I have a question I wanted to ask briefly.
Sure.
I think I missed the slide a little bit. So kinship is not eligible for GAP in Kansas. Is that what I saw?
See, it was Kansas, one of the states.
I think it was.
Yeah.
Okay.
So sadly, the subsidized guardianship doesn't mean you can't go to guardianship. And maybe, and I don't know off the top of my head, you have a state subsidy, but there's no federal subsidized guardianship in Kansas.
All right. Thank
Love to help you rectify that. I do know in Kansas you have something called sole permanency, which is a nice new permanency option, but no subsidized guardianship.
Okay. Thank you.
Yep, sure. Anybody else?
Heidi, there's a question in the chat about placing with relatives outside of the U.S. And if we have any resources.
The requirement under fostering connections does not say that you only have to notify relatives in the states. So start with notice. Notice should be comprehensive. It doesn't even define what all relatives mean. So you should absolutely be notifying relatives outside the country. Am I going to tell you that that's the easiest thing to achieve? No, it's not. In fact, I know I've got somebody in the group, Elaine, who might be able to give us some information, but I don't want to put
it was my question.
That's funny. I should have noticed that. So kinship caregivers who live outside the country are not eligible to become foster parents for the child. But that does not mean that they cannot place the child outside the country. It is rare. It can happen, but it is rare. And frankly, we have a hard time placing child from state to state under ICPC. So the thought of placing a child out of the country is probably so overwhelming, but it's not impossible. It would take a lot of advocacy, but I think it could happen.
I'll just chime in. I think it is very rare, but there's a case that we have that the child was placed out of the country with aunt and uncle that are prospective adoptive placement. But I'll tell you where the department struggled and they didn't recognize it till too late is that they didn't check on the requirements for this child to be in another country. So this child is placed there. They went up and hurried up and got a specific type of visa, but that visa didn't allow that child to receive medical care or education. And so the placement's really struggling. And by the way, this child also had very special needs and came from a DDD group home. And so I think they just hurried to get him there because they were disrupting rather than going and hiring a lawyer to find out about what the requirements were, because that was not the appropriate visa. They should have gone another way, and now they're dealing with the fallout from that. So I think it can be done, but I think you have to be very thoughtful and careful and make sure that you contact the right professionals before you do so. And sometimes those are professionals outside the child welfare system.
No,
That's
thank you.
a great
And
question.
I'm aware of that case, and in part that was the source of my question, is that we have all of these social work resources to help the engagement piece and the assessment piece, but the complexities of placement are so are so difficult. And we do help facilitate placements, but I know there are these legal barriers, and a lot hinge on the licensing requirements that don't apply in places where parents are now, some never entered the United States, and some now are kind of grappling with what to do when parents have been removed and are seeking to regain custody in their country kind of after this disruption. So anything that you find and can share is helpful to me. Thank you.
Well, we do have on the other end for parents that are out of the country, we have a transnational toolkit that actually that's what you're talking about. Yay. Okay, great. That's right. So yes, that'll be out one day, right, Elaine, soon. And then I'm looking forward to that.
Yeah.
And I will tell you, the issue of licensing non-resident kin is a very big one right now. It is something that Casey Family Programs is working on. A colleague, I think you know our colleague Christina Cooper, is working on looking at the cross-section between immigration and child welfare. Some states are phenomenal, and their licensing requirements do not require the kin to be a U.S. resident, or have any kind of papers, et cetera, documentation. Some states are not as good. Some states have written it in a very, way to sort of fly under the radar. This is a difficult time to be having that conversation, but we are trying to think through, are there ways to support kinship placement that can sort of bypass the question of sort of what is the legal status of the relative.
Yeah.
But yeah, and it's not easy, but it's very state dependent. It is incredibly state dependent. I can tell you New Mexico has like a very well written licensing standards that sort of allow for that. New York, we actually, I'm going to find it and put it in the chat, and you may have already seen it. We have a document that looks at the different state licensing criteria with regard to
I just put it in the chat, Heidi.
Oh, you put it in the chat. Thanks, Emily. Look at you. You're ahead of me. And it's going to be updated soon. That's a little bit old, but we're going to update that.
Heidi, there was a question in the chat from Linda with Ohio CIP about if we know of any pilot programs for Kemper's courtrooms.
So we last year were fortunate enough to partner with Ohio Connect, who does a really, really fabulous job in Ohio of working with kinship caregivers. And we've talked a lot to them about a Kin First courtroom. They have some pilots going on with, I want to say Cincinnati's legal aid, but I should probably know which one, but one of the legal aids in Ohio, I can get that to you. And it's not so much about the kin-friendly courtroom as much as providing legal assistance to kin in Ohio, which is something they're working on. But I know through that initiative, they've been able to identify some more kin-friendly judges. So I would say if there is work that's happening around a Kin First courtroom in Ohio, and I'm sure you probably already know the folks at that Ohio Connect, but if you don't, I can make that connection. They would be a very good resource. And we are also be thrilled to come to Ohio and work on that with you.
Thank you. Yes, we do know about the Connect and the legal access to justice, but we want to kind of focus our funding on the courts. So we've been in communication, but we haven't really thought of like a good pilot. So that's why I was trying to get ideas here.
Yeah, we would be happy to help do that. We love working with everybody, but we have a very nice relationship with CIPs, and we're happy to help in any way we can. And we'd love to get judges on board, and I'm sure Judge Quigley would be happy to help as well. I'm going to speak for her. Great, excellent. All right. Anybody else? Any other questions, comments, observations?
Thanks, Elaine, for that.
No,
Yeah.
this presentation is great. I wish we could like create all of those amazing resources that you have on this with like that extra little piece on the cross border, because it is a small component, but there's so much that I wish we could translate into that extra little bit. Close.
I like your suggestion, and I'm certainly going to take it to heart. One area that we want to add to the toolkit is tribal courts, and I'm putting on my wish list cross-border as well.
Yeah.
So assuming that we continue growing the toolkit, which is our plan, I will put that on my very short list of what to do next. And we'll be in touch. Not that we necessarily have a solution, but at least if we can compile the information and the resources to help people who are struggling with cases like the ones that you've identified, I think that'd be really helpful. So I'd love to add sort of those topics next. So thank you.
I think that's great, Heidi. You don't get anywhere, right, unless you take that first step. So good for you. That's a great idea.
And I'd already had sort of the immigration issue on the radar, but you're sort of posing an even additional piece of it. And that's not even just working with kin within the states, but how do you work with kin outside the country? So that's great. I love that. I would love to see this toolkit just keep growing and growing. So yeah, thank you for the suggestion. Excellent. Okay. It looks like there is a link in the chat to a survey, right? I don't know if you want to chat about the logistics of getting CLE, et cetera.
Yeah, that one's just from NCJFCJ. It just lets us know how the training went. It helps us guide our future training. So anything else you want to let us know how we did, something you're interested, please let us know that information and we can pass it along to our presenters.
Emily and Heidi, I think there's one question. Is this the Ohio program that was just referenced?
Yes, that's it, connect.org. And I just put another resource in the chat. We did a document on various models of legal kinship representation around the country. And so the Ohio one's mentioned in this document that I put there for anybody who wants to read more about the different ways various states are providing attorneys for kin. So Title 4E allows for legal representation of kin now. There's been a new rule, but we have yet to have a state take it up. So if you're in a state, you want to see more kinship attorneys in your state, and you want to figure out how to maximize 4E, contact us. We'd be really interested in working with the state to do that. But in the meantime, there are some fabulous kinship attorneys around the country. We only profiled 9. We're going to do more this year. There are lots of great people out there who do represent kin and try to assist with some of these complex issues. The toolkit's not aimed for them. They know what they're doing. The toolkit is really aimed at the legal folks who are in the courtroom, like I was, like every day, who maybe we want to help you, give you tools to work through some of these complex kinship issues. So hopefully the toolkit will do that for you, as well as the action alert, which will come out soon. Great. All right. Well, I think we don't have any more questions, so I don't want to keep you longer. You all have been incredible at sticking with us throughout and listening to all of our information, because we could talk about kinship all day. So we appreciate the audience.
Thank you, Heidi, Emily, Judge Quigley. I appreciate your time and efforts in this webinar. Just as a recap for everybody, we will be putting all these resources in an email, all the links, the slides, the recording. Once that action alert is approved and ready to go, we'll also be sure to send that out. Thank you all again for joining us.
Thank you all.
Thanks so much.
Thanks. Bye.